Crawford v. Washington afforded the Supreme Court an opportunity to abandon an indefensible interpretation of the Confrontation Clause and replace it with one that makes sense. The first paragraph of Justice Scalia's majority opinion laid out the constitutional problem. An eyewitness account of the crime was introduced against the defendant without any opportunity for cross-examination. The issue then was whether confrontation entails the opportunity to cross-examine, which in turn depended on the meaning of the word witnesses in the Sixth Amendment. The entire court acknowledged that the result would have been the same under the court's previous interpretation of the Confrontation Clause. However, the travel of the case through the Washington state courts exposed how that framework yielded arbitrary results. Each court to review the case considered different factors to arrive at conflicting results. Legal rules that yield unpredictable results are never valid, and it is bizarre that the dissenters thought that could be overlooked. To determine what witnesses meant when the Bill of Rights was drafted, the court looked to English and colonial common law. The court framed its history of the right of confrontation as a feature of the common law adversarial system of justice that distinguishes it from the civil law inquisitorial system. Unlike an inquisitorial system, which considers statements of absent witnesses as evidence against the accused, the adversary system presupposes live testimony subject to cross-examination. The majority derived two principles of adversarial justice from its historical research. The Constitution rejects inquisitorial methods of proof, particularly ex parte testimony. Consequently, testimonial out-of-court statements are inadmissible unless the declarant is unavailable and the defendant had a chance to cross-examine her. The court took a functional approach, reasoning that police today perform the same investigative and interrogative role that justices of the peace did in the time of Shakespeare, gathering evidence with a view to prosecution. To remain relevant, the Confrontation Clause must reach police questioning. Otherwise, its protections would be dissolved by societal change. Crawford reasons along the same lines as Miranda v. Arizona, which concerned police use of inquisitorial methods to produce confessions that were then introduced against the accused. Miranda called the privilege against self-incrimination the essential mainstay of our adversary system, and framed the issue the case presented as whether the privilege applies during police interrogation or only in court. In both Miranda and Crawford, the court sought to preserve and adapt adversarial rights to a changing world and prevent resort to inquisitorial methods, which the Constitution is not designed to check. Echoing Miranda's concern with the methods police use in interrogations, the Crawford majority noted that Sylvia Crawford answered leading questions from police detectives while in police custody. Because ours is an adversary system, it does not matter whether the judge believes the fruits of the police interrogation are reliable. The reliability of the statement can be measured only through questioning by the accused. The accused and his constitutionally guaranteed counsel are uniquely motivated to treat testimony skeptically and uncover any flaws. Statements not subject to adversarial testing before the jury are unreliable as a matter of law and inadmissible. Crawford recognized that allowing police interrogations to substitute for in-court direct and cross-examination risked nullifying the Confrontation Clause. Other types of hearsay, however, do not similarly undermine the adversary system. It is only hearsay that is offered effectively in lieu of in-court testimony that concerns the Confrontation Clause. The constitutionality of admitting an out-of-court statement against a criminal defendant has nothing to do with whether that statement is admissible under the rules of evidence. The inquiries are independent of each other. The constitutional concern is whether the statement is testimonial. If it is, the accused must have the chance to cross-examine the declarant, in court if possible. If the statement is not testimonial, then the confrontation clause is not implicated. Crawford did not have to consider the outer limits of what qualifies as testimonial hearsay. The court revisited the concept a couple of years later in two cases consolidated for decision under the style of Davis v. Washington. In Davis, the court ruled that statements made to get the police to respond to an emergency are not testimonial. This conformed to Crawford's functional approach, which maintains that the confrontation clause is concerned with statements recounting past events that should be made in court where they can be cross-examined. The court first considered whether some of Michelle McCrady's statements to a 911 operator were made to seek help and were therefore not testimonial. The court listed three characteristics of such statements. First, her statement was narrating events as they unfolded, rather than retrospectively. Second, there was in fact an emergency because McCautry was being assaulted. Third, the questions and responses related to information relevant to resolving the emergency. Davis pointed out that McCautry's conversation included both non-testimonial and testimonial statements, but the Supreme Court was asked only to consider the non-testimonial ones. Nonetheless, the court explained that only the non-testimonial parts were potentially admissible. In the companion case, the court considered Amy Hammond's statements to a police officer responding to reports of a fight between her and her husband. The majority held those statements were testimonial. The court pointed out that there was no evidence of an ongoing emergency. Hammond did not claim there was any emergency. The officer questioning her admittedly was asking about a fight that had ended. Justice Thomas dissented on the ground that Hammond's statements to police were not formal like Sylvia Crawford's, because Crawford was Mirandized. Amy Hammond, however, was never suspected of any crime, much less taken into custody. Justice Thomas never explained how the questioning of a witness could satisfy his test, and gave no substantial response to the majority's point that all official questioning by law enforcement officers is formal in the sense that there are serious consequences for being untruthful. In response, the majority explained that today's police respond to emergencies as well as question suspects and witnesses. It makes no sense to say that a witness's statement is non-testimonial because the police questioned her at a house where a crime just occurred, rather than at the police station as in Crawford. People understand that the obligation to be truthful with police investigating a crime is similar to the obligation to tell the truth in court. Justice Thomas's second point was that the court's primary purpose test was not really as much about purpose as about the function that the out-of-court statement performs. A functional approach would ask what the out-of-court statement is relevant to, but this would be difficult to apply to such statements as the name of McCautry's assailant. That name was relevant both to preparing the police to meet the emergency and to prosecuting a crime. In Michigan v. Bryant, the court revisited what constitutes an emergency. The ostensible reason for taking the case was to consider an emergency arising in a context other than domestic violence. The real reason for taking the case was to alter Davis's primary purpose test. As Justice Ginsburg pointed out in dissent, existing law already made the statements at issue in Bryant almost certainly non-testimonial and admissible. Footnote 6 in Crawford had noted that the common law accepted from the confrontation requirement statements made by a person who believed he was dying about what caused his death. The prosecution abandoned that argument and therefore could argue only that the statements of a dying man made in response to police questioning about how he got shot were not testimonial. Justice Scalia, in his separate dissent that ridiculed the majority's thin analysis, suggested that the majority in fact sought to cut back on Crawford's holding for policy rather than for legal reasons. He contended that the majority was attempting to revive the pre-Crawford understanding of the Confrontation Clause, one that allowed judges freedom to admit or exclude testimonial hearsay by picking and choosing the circumstances to weigh heavily in the analysis. Justice Scalia identified two specific ways in which Justice Sotomayor's majority opinion mangled Crawford. First, the majority contended that a statement's supposed reliability is relevant to determining whether it is testimonial. The whole point of identifying testimonial hearsay, however, is to withhold from judges the power to decide what statements are reliable. Crawford's point is that reliability can be determined only through cross-examination. Second, the Bryant majority's approach is just as manipulable as the jurisprudence that Crawford supplanted, because reliability is just one of innumerable factors that can influence whether a statement made following a violent crime is testimonial. There is no doubt that Justice Scalia was correct. Between the time that Crawford and Bryant were decided, Justices Stevens, Souter, O'Connor, and Rehnquist left the court. Justice Kagan, who replaced Justice Stevens, did not participate in Bryant. Justices Alito, Roberts, and Sotomayor, who replaced the other three departed justices, joined with Justices Breyer and Kennedy to resurrect a discredited interpretation of the Constitution. These justices asserted that Davis was predicated on the notion that people don't lie when reporting an emergency. Even though the majority opinion provides pin cites to Davis everywhere else, this particular assertion has no citation. That is because it is an outright lie. Davis was in no way based on reliability, just as Justice Scalia explained. Bryant is a case where a bare majority of 5 justices, so-called conservatives and so-called liberals alike, banded together to blunt a recent constitutional ruling by 7 justices. It did so while pretending to faithfully apply that ruling, exposing the fact that there was no good reason for doing this. The only reason for it was that the new justices were politically hostile to Crawford. That makes this an illegitimate ruling, one based on policy rather than on law. Justice Thomas concurred in it for independent reasons. 4 years later, the court unanimously agreed that statements an abused 3-year-old child made to his teachers were non-testimonial, but the same majority as the Bryant court, now joined by Justice Kagan, reiterated its watered-down interpretation of Crawford. It would have been easy to write a unanimous opinion in Clark. All 9 justices agreed that the exchange between the child and his teachers was not solemn enough to be testimonial, because nothing could impress upon that declarant the importance of being truthful in those circumstances. Instead, the majority took the opportunity to try to cut back the Confrontation Clause by gratuitously suggesting that there may be testimonial statements beyond its reach. This was so unjustifiable that this time, Justice Ginsburg joined in Justice Scalia's scathing concurrence. Their opinion implied that Justice Alito, as well as Justice Sotomayor, were anxious to overrule Crawford because both recently appointed justices had worked as prosecutors. It taunted Justice Alito for apparently having tried and failed to get 5 votes for overruling Crawford. And it reminded the lower courts that just about every word of Clark is dicta, and that, for the time being, Crawford remains the law.